Rule 110, Section 1, Institution of Criminal Actions. Criminal actions shall be instituted as follows. Paragraph A. For offenses where a preliminary investigation is required pursuant to Section 1 of Rule 112 by filing the complaint with the proper conducting the requisite preliminary investigation. Paragraph B. For all other offenses, by filing the complaint or information directly with the municipal trial courts and the municipal circuit trial courts, or the complaint with the office of the prosecutor. In Manila and other chartered cities, the complaint shall be filed with the office of prosecutor unless otherwise provided in their charters. Section 2. The complaint or information. The complaint or information shall be in writing in the name of the people of the Philippines and against all persons who appeared to be responsible for those offenses involved. Section 3. Complaint defined. A complaint is a sworn written statement charging a person with an offense subscribed by the offended party. Any peace officer or other public officer charged with the enforcement of the law violated. Section 4. Information defined. An information is an accusation of writing charging a person with an offense subscribed by the prosecutor and filed with the court. Section 1, Rule 111, Prosecution of Civil Action. Section 1, Institution of Criminal and Civil Action. Paragraph A. When a criminal action is instituted, a civil action for the recovery of civil liability arising from the office offenses charged shall be deemed instituted with the criminal action unless the offended party waives or decline the civil action. So reserve the right to institute is separately or institution the civil action prior to the criminal action. The reservation of the right to institute separately the civil action shall be made before the prosecution starts, presenting the evidence and under circumstance affording offended party a reasonable opportunity to make such reservation. When offended party seeks to enforce civil liability against the accused by way of moral, temporary, or exemplary damage without specifying the amount thereof in the complaint or information. The following fees, therefore, shall be constituted first lane on the judgment awarding such damage where the amount of damage other than actual is specified in the complaint or information. The corresponding filing fees shall be paid by the offended party upon filing thereof in court, except otherwise provided to these rules. No filing fees shall be required for actual damages. Rule 110. Preliminary investigation. Section 1. Preliminary investigation defined. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for a trial. Rule 113. Arrest. Section 1. Definition of arrest. Arrest is taking of a person into custody in order that he may be bound to answer to the commissions of an offenses. Rule 114. Bail. Section 1. Bail defined. Bail is an security given for the release of a person in custody of the law furnished by him or a bondsman to guarantee his appearance before any court as required under the condition hereinafter specified. Bail may be given in the form of corporate security, property, bond, cash deposit, or recognizance. Rule 117. Motion of quash. Section 1. Time to move to quash. At any time before entering his plea, the accused may move to quash the complaint or information. Section 2. For the contents, the motion is quashed shall be in a writing signed by the accused or his counsel and shall distinctly specify its factual and legal grounds. The court shall consider no ground other than those stated in the motion, except lack of jurisdiction over the offense charge. Section 3. Grounds. The accused may move to quash the complaint or information on any of the following grounds.